Judgment in the appeals HJ Iran and HT Cameroon against the Secretary of State for the Home Department.
These appeals raise an important question as to the test which is to be applied in deciding whether a homosexual person who fears persecution on the grounds of his homosexuality, if returned to his home country, is entitled to claim asylum in this country as a refugee. The 1967 Refugee Convention, to which the United Kingdom is party, provides that a person is entitled to humanitarian protection if, owing to a well-founded fear of being persecuted for reasons of membership of a particular social group, is outside the country of his nationality and, owing to such fear, is unable to avail himself of the protection of that country. Homosexual men and women may be considered a particular social group for the purposes of the Convention. HJ and HT, the appellants in these cases, are homosexual men. They are from Iran and Cameroon, respectively. They seek asylum in the United Kingdom on the basis that they have a well-founded fear of being persecuted on grounds of their sexual orientation if they were to be returned to their home countries. In both Iran and Cameroon, it is a criminal offense to engage in consensual homosexual acts. It is punishable by imprisonment. In Iran, where HJ comes from, such conduct may also be punished by death by hanging. HT was the victim of an exceptionally violent homophobic assault while he lived in Cameroon. The issue in this case is whether it is permissible under the Refugee Convention to deny HJ and HT asylum on the ground that if returned to their home countries, they can be expected to conduct themselves discreetly so as to conceal their sexual identity in order to avoid coming to the attention of the state authorities, and by this means evade persecution. The Court of Appeal held that such refusal was compatible with the Refugee Convention, provided that it could be said that HJ and HT could reasonably be expected to tolerate such conditions. The appellants appealed to the Supreme Court, contending that the reasonable tolerability test applied by the Court of Appeal was contrary to the object and purpose of the Refugee Convention, which is to secure protection for the fundamental rights of vulnerable groups. The Supreme Court has held unanimously that the appeals must be allowed. To compel a homosexual person to pretend that his sexuality does not exist, or to suppress the behavior by which it manifests itself, is to deny him his fundamental right to be who he is. Homosexuals are as much entitled to freedom of association with others who are of the same sexual orientation as people who are straight. The Court holds that the reasonable tolerability test relied on by the Court of Appeal is incompatible with the Refugee Convention and should not be followed. The Court has also provided detailed guidance for the lower courts and tribunals as to the correct approach in cases where a person claims asylum on the grounds of their sexual orientation. HJ and HT's cases are therefore remitted for further consideration.
Judgment in the appeal, Southern Pacific Securities and Walker and another.
Well, Clarke will give the judgment.
This appeal is about consumer credit. The parties entered into a fixed sum credit agreement in April 2005, under which the respondent, Southern Pacific Securities, lent the appellants, Mr. and Mrs. Walker, the sum of £17,500. In addition to the loan, a broker administration fee of £875 was advanced to the appellants to enable them to pay for the arrangement of the loan. Interest was payable on the broker administration fee at the same rate as on the loan of £17,500. The credit agreement set out the amount of credit as £17,500, being the loan, and the total amount financed as £18,375 being the loan together with the broker administration fee. Under Section 127, subsection 3 of the Consumer Credit Act 1974, agreements predating April 2007 are only enforceable if they contain certain prescribed terms. The prescribed terms for agreements such as the agreement entered into by the parties in this case included a term stating the amount of credit. Section 9, subsection 1 of the Act defines credit as including a cash loan and any other form of financial accommodation, and Section 9(4) provides that for the purposes of the Act, an item entering into the total charge for credit shall not be treated as credit, even though time is allowed for its payment. The appellant's case is that the credit agreement incorrectly states the amount of credit, and therefore by Section 1273 of the Act, the agreement is unenforceable. Their case is that the true amount of the credit was not the loan of £17,500, but £18,375, which is the amount shown in the agreement as the total amount financed. The appellants succeeded in the County Court, but failed in the Court of Appeal. The issue in this appeal to the Supreme Court is the correct definition of an amount of credit under the Act, and whether the Act permits interest to be charged on a sum, such as the broker administration fee, which is not part of the total amount of credit, but rather is a charge for credit. The Supreme Court unanimously dismissed the appeal, essentially for the same reasons as given in the Court of Appeal. Although the broker administration fee of £875 was advanced to the appellants and repayable with interest, it was part of the total cost of or charge for credit, and therefore cannot be treated as part of the credit. Section 9(4) provides that an item entering into the total charge for credit shall not be treated as credit. It follows that if an item is part of the total charge for credit, it cannot form part of the amount of credit. The relevant authorities stress that the first step is to assess the total charge for credit, so that those items financed by the creditor which form part of the charge for credit can be identified and stripped out before the amount of credit is determined. In the judgment of the court, there was no doubt that the broker administration fee was part of the total cost of the credit. It was a fee paid to intermediary brokers and was a cost to the appellants of borrowing the £17,500. Once it is accepted that the fee was part of the total charge for credit, it follows that it must be stripped out of the amount of credit, and by Section 9(4) cannot be treated as credit. The court then considered whether that conclusion is affected by the fact that the respondent was lending the fee at a rate of interest. The court concluded that it is not. Section 9(4) does not prohibit the charging of interest. If the fee itself was part of the total charge for credit, it follows that the interest on the fee was also part of the total charge for credit and cannot be treated as credit. Contrary to the appellant's submissions, interest is not a necessary feature or indicator of credit. In these circumstances, the form of the agreement complied with the terms of the Act and is not unenforceable, and the appeal was accordingly dismissed.
The court will now adjourn.